Can the police arrest you for looking inside your own car? Sounds ridiculous, right? But here's the honest answer. It depends. And when it comes to what you're actually allowed to do when an officer confronts you on the street, most people get this completely wrong. In this video, I'm going to walk you through two real-world situations. First, what happens when an officer stops you and demands to know what you're doing near a vehicle, and whether you even have to answer. Second, what happens when they want to search that car, and the exact moment they're allowed to. I'll give you the real charter sections that protect you. I'll bust a couple of myths that get people into trouble, and I'll give you the exact words to say so you don't accidentally hand away your own rights. Quick reminder before we start, I'm giving you general legal information, not legal advice, and this is Canadian law only. Stick with me to the end because the third point I cover is the one almost nobody knows. Picture this. A man is standing in a parking lot at night, leaning down, peering through the window of a car. An officer rolls up, lights on, and says, "What are you doing? Whose car is this? Show me some ID." Now the man freezes. And here's where things go sideways for a lot of people because of one belief. Here is a common misconception, that the moment a police officer asks you a question, you're legally required to answer it. You're not. In Canada, you have the right to silence. That right comes from Section 7 of the Charter, life, liberty, and security of the person, and the Supreme Court of Canada confirmed it protects your right to stay silent when dealing with police in a case called R.V. Hebert back in 1990. You generally do not have to explain yourself, justify where you're standing, or talk your way out of a situation. But, and this is important, there's a difference between staying silent and refusing to identify yourself. So let's be precise, because I see people make this mistake all the time. There is no general law in Canada that forces you to carry ID or hand it over just because an officer asks. If you're simply standing on the street or in a parking lot, you are usually not required to produce identification. That changes in specific situations, the biggest one being if you are driving. If you're behind the wheel of a vehicle, provincial highway traffic laws across the country require you to produce your license, registration, and insurance on request. But standing beside a car, looking through a window, that's not driving. So the demand for ID doesn't carry the same weight. Now, can the officer detain you at all? Yes, but only under specific conditions. Police in Canada have what's called an investigative detention power. It comes from a Supreme Court case called R.V. Mann from 2004. Under that rule, an officer can briefly detain you only if they have reasonable grounds to suspect you are connected to a particular crime. Not a hunch, not "you looked nervous." A real, articulable suspicion tied to an actual offense. And your protection against being held for anything less than that comes from Section 9 of the Charter, which says everyone has the right not to be arbitrarily detained or imprisoned. So if an officer is detaining you, you're allowed to ask why. Here's the exact phrase I want you to use, word for word. "Officer, am I being detained? And if so, what is the offense you suspect me of?" That question does two things. It forces them to either let you go or commit to a legal reason. And under Section 10A of the Charter, once you are detained, the officer is required to promptly tell you the reason for that detention. That's not optional for them. That's the law. And if they confirm you're being detained, here's your follow-up line. "I'm going to remain silent, and I'd like to speak to a lawyer." The second you're detained, Section 10B of the Charter kicks in. Your right to retain and instruct counsel without delay. You don't have to wait until you're arrested. Detention is enough to trigger it. One thing I'll be straight with you about. Whether a particular stop counts as a detention can be a gray area. The Supreme Court looked at this in R versus Grant in 2009 and laid out factors for figuring out when an interaction becomes a real detention versus just a casual conversation. It's not always black and white, and it can come down to the specific facts. So if you've been in a situation like this, that's a question for a lawyer, not something to settle on the side of the road. Now let's say the situation escalates. The officer decides he wants to search the car, or search you. He says, "Open it up, let's see what's inside." This is where a lot of people cave because they think refusing makes them look guilty. So let's clear it up. Section 8 of the Charter is your shield here. It says everyone has the right to be secure against unreasonable search or seizure. The starting point in Canadian law is that a search without a warrant is presumed to be unreasonable. The burden is on the police to justify it, not on you to prove they shouldn't. Now, here's the honest nuance, because I'm not going to oversell this. Cars get less privacy protection than your home. Courts have recognized that there's a lower expectation of privacy in a vehicle, so there are situations where police can search a car without a warrant. For example, if they've lawfully arrested you and the search is connected to that arrest, if they have grounds and there are urgent circumstances, or if you actually consent. That's real, and it varies with the facts. But here's the part you control. Consent. If you say, "Sure, go ahead," you've handed them a legal search on a silver platter, and you've waived your own Section 8 protection goodbye. You are never obligated to consent to a search, and you can decline clearly and politely. Here's the exact phrase, word for word. "I do not consent to any search of my car or my belongings." Say it calmly, Don't argue, don't physically resist, don't reach for anything. If they search anyway, you let them, and you fight it later, in court, where you'll actually win if the search was unlawful. The key is that you said it out loud and on the record. That single sentence can be the difference between evidence being allowed in court and evidence being thrown out. And here's the misconception I really want to kill, that if you have nothing to hide, you should just let them search. That's not how rights work. Asserting your rights is not evidence of guilt, and an officer is not allowed to treat your silence or your refusal to consent as proof you did something wrong. Standing on your rights is exactly what they're there for. If they do arrest you at this point, the same protections apply, but stronger. Section 10A. They must tell you what you're being arrested for. Section 10B. They must give you access to a lawyer without delay. And Section 7. You keep your right to silence the entire time. You do not have to explain, narrate, or defend yourself. The phrase stays simple. I'm going to remain silent and I want to speak to a lawyer. Repeat it as many times as you need to. You don't owe them a story. So let's bring it all together. 3 things to remember. Number 1. You generally don't have to answer an officer's questions, and outside of driving there's usually no law forcing you to show ID. Your right to silence comes from Section 7, and your protection against being held for no good reason comes from Section 9. Ask the magic question, am I being detained, and what's the offense? Number 2. You never have to consent to a search. Section 8 protects you, and a warrantless search is presumed unreasonable. Cars get less privacy than homes, so the rules are situational, but consent is the one thing you fully control. Refuse clearly, don't resist, and fight it in court. Number 3. The moment you're detained or arrested, Section 10 gives you the right to be told why and the right to a lawyer without delay. Use it immediately. Talk to the lawyer, not the officer. Now, because so much of this depends on the exact facts and on which province you're in, please don't treat this video as the final word on your specific situation. If something like this has happened to you, talk to a qualified Canadian lawyer. Save this video so you've got these exact phrases when you need them. See you in the next one.